All right. Well, I've got some things up for today, which it's going to be kind of harder to understand lesson today, which is fine. Um, it can be complex, so don't be too upset if you find it hard to understand. Because a lot of this stuff is usually taught in crime, which is usually your second level. You gotta just take this as a learning curve and allow it to help you for your second level as well of law. So we're going to be exploring the legal system in Australia, and I want to focus on two important concepts. One being codified law and the common law system. I think we're going to discuss what those terms mean. How do they differ, and how are they currently being applied in Australia? And at the end, I will show some examples of how this is applied and what does this exactly mean. So Australia follows a legal system that combines both elements of common law and codified law. The dual approach is influenced by its history, with the country being a former British colony. The combination creates a unique blend that shapes the way laws are made and interpreted. Well, if we think of how Australia was made originally, and I'm going to show a picture of Australia originally when the British came. So if we go, uh, so this is how Australia was originally divided. Just trying to find a map. Okay, so I'm just going to share this map for a second so I can best colonized Australia. Okay. So I want to share this colonized Australia. What you have is Australia wasn't when the British invaded Australia, it wasn't a united country. We weren't a federated states. Basically, each of these states here, Queensland, New South Wales, Victoria, they were each an individual country. And what happened is when the British first came to Australia, they stopped in Tasmania, as Tasmania was a penal colony, mainly a prison. After a couple of hundred years, they moved to New South Wales, to Port Moresby and stuff like that. And then eventually each country got a little bit of like the British people living there, and each country had its own laws, which we still see today, but we're more of a combined country now. So we combined all the states, so we're one country instead of multiple different countries. And I'm not sharing some of the indigenous lands here because that's a big map too. That Indigenous Australia was a country that was made up of more than 250 indigenous countries. Even though it's one country like this, it had each individual tribe owned different portions of land. So if we show you this Australian indigenous map, so if we look at that, so if we have this only shows like kind of a representation of how Australia was broken up. So each of these were indigenous cultural countries. So Australia were I don't know if you even know if it was Australia at the time, but um, this whole country here was made up individually of different indigenous groups. Um, and then when the British came through, they kind of divided it up into Victoria, New South Wales, stuff like that, um, to keep that kind of simple. So let's define what common law refers refers to law developed by judges. All right. So you got the judiciary. So the judiciary is basically a judge. Now, this law doesn't come from the magistrates court at all. You can't really use that in the higher courts. They won't listen to it. But the magistrates court will always take on laws from higher courts like the Supreme Court and County Court and the High Court of Australia, but they won't listen to the magistrates' decisions in previous cases. If you think about it, the magistrates' court is really just an application process. They do make decisions, but there are requirements for the decisions that they can make. There are limits to those decisions that the magistrates' court can make. Um, so if we have a look at I believe I don't know if they what's wrong, Lizzie? Are you laughing over there? I don't know if that's still the same thing, but I believe it was a criminal sentence of 3 years or less. I don't know if they've changed that. Uh, they oversee criminal, civil, and family matters, and I think I'm just seeing if what's the maximum penalties they can hear, because after that you go over to the county court and then up and up and up and up, basically. And anything that is greater than 3 years, like if it's 5 years or more, has to be held by the county court. And murder charges go direct to the Supreme Court. Anything like life sentences like that doesn't go to the county court. They won't make decisions on. So the maximum penalties, which I'm just going to see if they've made any edits to it. Yeah, and I'm going to share this with you as well. Share my screen, maximum penalties. Okay. And that. Okay, so the maximum penalty for the offence of the heaviest sentence that can be imposed for the offence or the offences at the maximum penalty in the defined legislation is the maximum penalty that many offences set according to the penalty scale is outlined in the section of the Sentencing Act, right? So, with the separation within these, um, so basically, what will happen is that the courts will have a system on what cases can be heard there and what cases can't be heard there. What power do they have and don't they have? So if you look here, you'll have this. The Sentencing Act of 1991, Victoria, restricts the sentences that the magistrates court can order in the magistrates court system to 2 years of imprisonment for a single offence, and now it's 5 years imprisonment for multiple offences. And the maximum fine or penalty units is $493,975. So if your offence goes higher than 5 years, if it goes higher than 5 years or more than $493,000, you have to be heard at the next court. They don't have the power to make, they don't have the legislative power to make decisions like that. The county court and then the Supreme Court. So cases of $1 million or more goes to Supreme Court, and then any more higher funds than that go to the High Court of Australia. I know Gina Rinehart's case with her children went there because of the amount of money that was involved in the cases. I think it was more than $3 million plus. So um, it kind of just um, depends on what the kind of money that you're talking about as well, and the circumstances involved. Um, so common law refers to law developed by judges through decisions in an individual court case. This means the legal principles are established through rulings in court rather than being written in set statutes or codes. So, when we talk about legislation that comes from the the parliament will have a guideline. It's kind of like a guideline, right? And it's kind of like an instrument that should guide the judiciary on what they want the judiciary to do, and the judiciary is there when they make the rulings in a common law system. That's what becomes the precedent, not the legislation, right? So when you go to court, you'll be using other cases, and I'm going to show this later, of how we find out what those cases are. Um, need to finish this. So, the concept of common law originated in England. Actually, it kind of the trial process started off with the Anglo Saxons, and the Normans. If you combine the Anglo Saxons and the Normans together, that's what leaves us with our kind of common law system that we have. Um, so one of the most important features of common law is the doctrine of precedence, and that's like based on the judge's decisions or what makes good law. I will also show you that in later, so I don't have to keep leaving these pages and stuff like that. Um, sorry, give me a second. So imagine a case where the High Court rules on new issues like the right to privacy. Future cases that deal with privacy laws would rely on the High Court ruling as a guiding principle unless the court decides to overturn it or modify it. Yeah, so that happens with any law. Um, Basically, any law can be overturned if it's no longer serving the best purpose of the legislation. So if the precedent is no longer and the legislation no longer serves its purpose, or maybe something changes in today's world, and maybe a 1920s piece of legislation just doesn't work in a 2024 era, then yes, it'll be overturned. There have been a few cases that where that's happened, and I could show those as well. But I want to keep it simple because. So let's talk about codified law in Australia. Codified laws refer to laws that are written down in formal, systematic set of rules or codes. These rules, typically enacted by the legislator, being Parliament, are meant to provide clear guidelines for the behaviour and procedure. So basically, what that means is that when Parliament makes rules with legislation and sentencing, it will say how exactly the legislator should rule. It kind of takes away that ability to kind of use your own determination. And I'm going to show you a case where a judge has done this, and it's been like where a judge had made this ruling based on their own decisions, and I'm going to talk about that later. Um, Australia's codified law is largely based on statutes or Act of Parliament. For example, the Criminal Code or the Australian Consumer Law, which outlines specific rules and regulations that must be followed. The key feature: written statutes and codes, codified laws are clear and specific and publicly accessible. They are usually organised into comprehensive codes that cover various areas of law, such as criminal law, contract law, and family law. If you look at the criminal code of a statute, you'll find specific provisions that defines crimes like theft, assault, murder, along with their penalties. These laws are written down and need to be followed precisely, and I'm going to show you that because I've got a reference. I've got a case up right. I've got a statute up right now. I'm going to show you the difference between what judges can do, what judges sometimes, what the open laws allow judges to do. And once you start to see this in practice, you'll go, oh, okay, makes sense. Okay, so a source of law derived from judicial decisions, I've already said that, created through the legislator, flexibility. So flexibility is in common law. So judges have more flexibility. Judges can adopt the law to new situations, and judges can be put their politics into law. So that has happened in a few cases in Australia recently, and I'll show that as well. Judges can interpret and apply laws based on past precedents, and these can be difficult to access as it's based on case law. Codified law is a little bit easier because it's written in the legislator and you don't have to go looking for specific cases for that. So examples of that would be the Criminal Code, the Family Law Act, and the Australian Consumer Law. Basically, in order to understand what your rights are and protections are and imprisonments are, it's all in the legislation, and you should not have to go and look for particular cases to inform your understanding, because it should be all same. Australian legal system uses both. Codified laws will provide a clearer, detailed rules, especially in criminal law and taxation. Common law helps to fill the gaps, and where specific statutes or statute will need interpretation. So let's talk about common law, right? Let's say how this might work in practice, right? So let's say in a common law case, the court's deciding whether a person's behaviour constitutes negligence. The judge may look at the court's past decisions to see how a similar case was handled and apply those principles. Or in codified law cases, such as interpreting the criminal code, a judge will look at the exact wording in the statute. And if the statute is ambiguous, the judge might turn to statutory interpretation to clarify the meaning. And I'm going to show you some things as well that's happened, and we can debate this. All right. So let's talk about some cases. Actually, I'm going to bring that up. Give me for a second. I'm going to bring this up for a second. Okay. So this is for the coward's punch. Recently, I think since 2001, it might have been sooner than 2001, we had a hike in offences where young people were punching each other in the back of the head, called the king hit. And punishment laws, and it needed to be done. Let's just say that. All right. So it says here, must impose a sentence that reflects the totality of the offending and constitutes the course of the conduct, and must not impose a sentence that exceeds the maximum penalty prescribed for the offence if charged in a single offence. Right? So we can begin to see that it's actually telling the judge, this is the sentencing guidelines, by the way. It's telling the judge that you must give the minimum, but it can't give any more than the maximum, right? So it's not giving, it's not allowing any leeway for the judge to determine anything. It's not leaving that open. So I know this is a 10 years sentencing. So in sentencing a youth offender age 16, this has changed now. We'll talk about this and more. But under 18, at the commission of the indictable offence at the Supreme Court, County Court, you must have requirement in the Act of a non-parole period. You must have specified minimum non-parole period of imprisonment to be fixed or specified minimum term of imprisonment. So they're saying now that you must serve a minimum term. These are no longer just maximums, right? You must serve at least blank, right? But the maximum is 10 years, right? So now, how do we go about how do we go about finding what the penalty is for this? Let's go find the penalty. Mm, cool. So the I know this is 10 years. So they're taking into account whether the offender pleaded guilty at the first stage of the offence. So when you bought the court, you actually get a discount. Um, sentencing standards. Okay, let's search this up because this is all over the place. Okay, so it defines the term sentencing, and so it doesn't give me the period of time. Be nice if it was just juicily laid out. Sentencing guidelines. Okay, let's have a look at it. It's prescribed whether the offence was motivated or by prejudice. This shouldn't matter. Any loss or damage, aggravating and mitigating circumstances, sentencing. So these are all the things that the judge has to put into their determination for sentencing as well. So um, I know it's 10 years, so it's conduct. It's just guiding the judge, basically. You must, if a person's got drugs, must submit them to a drug alcohol treatment. You must, so subject. So it's telling the judge here that you cannot be achieved in community corrections order. One. So if a sentence cannot be achieved by imposing a community corrections order, pardon me, if you must not impose a drug treatment order and must not impose a community corrections order and must not impose a fine. So if the court finds that this these behaviours can't be corrected by that, then it must not be considered to be given. Okay. Um, so that's to do with the sentencing guidelines. So it's telling me I'm just looking for the standard sentence. If I don't talk for a bit, I'm just trying to find sentences. So it's saying that a fine exceeding an aggregate fine exceeding 20 penalty units. Mm, okay, so in sentencing the offender, the court imposes a less severe sentence than it would otherwise have imposed because the offender pleaded guilty to the offence and the sentence imposed the offender is to include and under a Division 2 to Part 3 or the order offenders serve a term of imprisonment or a community corrections order. So that means that not only can they send you to a prison, but they can also force you to serve a term of community under a community corrections order. Um, that can only be applied for a maximum of 2 years. So that restricts a judge that if your prison time, the time in prison and the time on a community corrections order has to be taken into account because you can't apply a community corrections order for any more than 24 months. That's maximum time for a community corrections order. Otherwise, if it is above that, then the only thing you can really do is sentence them to prison for a certain X amount of time. So, for argument's sake, if I sentence you to prison for 10 years and you can only end up on a 24-month community corrections order, so let's say I let you out at 8 years. So I go, okay, you have to serve a minimum term of 8 years, and then on your last 24 months, you must serve that on a community corrections order in the public. Then you could probably do it. But you can't if someone's maximum term is 10 years, then the community corrections order is not gonna be, like, viable for that. You have to serve there's no other option but to send them to prison sometimes. Um, and it's the same thing with the penalty units. I'm pretty sure there's no parole for this at the moment. They don't do parole for serious crimes like this, anymore. So it's shutting down the judge's interpretation, um, of so it opens up the judges to kind of make their own determinations, but this is shutting that down. It's kind of legislative binding them to make these decisions. And that's the difference between so if I show you I'll get rid of this just for a second. I've got to find out what that person's name is too, so I can make so if I go and find that person's case and find her name, because I don't know the person's name. Uh, Evie, okay. So I'm gonna find a case just for a second because this is a case where it was left up to the magistrate to make the decision. I'm gonna go to the first case for a second. Um, so I'm just gonna go find the first case because there's another one where it was appealed because the judge was really lenient, really, really, really lenient. Like, okay, so I'm gonna go here. And this was basically after a transgender person entered into a 7-Eleven with an axe and attempted to murder 2 people and a whole bunch of other serious things, right? And basically, this judge was left to open to interpretation. And they the offense so if I go so this is what the counts were, the charges are down here, right? So the offense, following a trial by jury, so the person pleaded not guilty. The respondent was found guilty by the following offences committed at Enmore in early hours of the morning of January 7th, 2017. Count 1, wounding Benjamin Rimmer with intent to murder, an offence under the Section 27 of the Crimes Act 1900, punishable by the maximum penalty of 25 years of imprisonment with a standard non-parole period of 10 years, right? So you must serve a minimum of 10 years of your sentence of 25 years, right? But there's no minimum term for this, right? So the judge, it leaves that judge open to go, oh, okay, how long should this person serve then? Right? Now she got count 3, causing grievous bodily harm to Sharon Hecker with intent to murder. That is also punishable by the same maximum penalty and non-standard parole period. So this is 2 counts of that, right? And now there's count 5, attempting to wound Shane Redwood with intent to murder. And that's also the maximum penalty of 25 years of imprisonment with no standard point of parole. Now, if someone did this, you wouldn't get parole. Generally, you shouldn't be actually even be considering parole. But anyway, that's not based on my opinion. But on 2018, a jury, January 2019, sentencing judge imposed an aggregate sentence of imprisonment of 9 years. Right, 9 years, commencing 7th January 2017, with a period of parole for 4 years. That's a really lenient sentence. That's a really, really lenient sentence. Like, this person could be possible for parole in a period of 4 years and 6 months for 3 counts of attempted murder. Right? So basically, this allowed the judge to kind of go and decide their own thing, basically, is that this is what the judge did. In accordance with Section 53A of the Crimes Act sentencing procedure, His Honour noted the following indicative sentences. The count 1 offence, imprisonment for 7 years with non-parole period of 4 years. So the first offence was 7 years with a non-parole period of 4. So you could be out in 4 years, basically, right? For the third offence, imprisonment for 6 years and 6 months with a non-parole period of 3 years and 6 months. Count 5 was imprisonment for 5 years. But in total, if you bring them all together, the judge was going to let this person out in about it was eligible for parole in about 4 years, right? Which is really lenient. I mean, I don't know how the judge came up with this decision. So the Crown, well, this is on the application to appeal this decision by the DPP. The Crown contends that the aggregate sentence imposed was manifestly inadequate. I agree. The facts offences were not dispute. You can't dispute the facts in the case because the incident was caught on camera. At the hearing, the court Crown sought to play the CCTV, which depicted the offences committed. Right? Now, how can we get to the point to where judges can now make very lenient sentences, right? So it kind of it opens it up to the judge's interpretation. I wouldn't even say to their own politics, even, right? That a judge could sit there and go, okay, you got mental illness, I'll discount you heavily, right? I'm going to give you a heavy discount on that because of your mental illness. Or I'm going to give you, let's just say you got disability, I'm going to give you a very heavy discount on your disability. That's what I think's happened, right? Because in the case there's obviously gender dysphoria that was used, drugs, um, something else, whatever it was, but it kind of opens up judges to do these lenient rulings, right? Very lenient. And the person is resentenced to much longer, which is what is needed for that case, right? But the point is that the difference between codified law and common law, right? So if we go to get rid of those for a second, get rid of the Sentencing Act. If I go to Jade Barlow again, and I want to show something in particular, I want to go to the Crimes Act, the Criminal Code. So if I share my stream here, and you'll see that what I'm doing, particularly. I want to go to where codified law is, right? So I want to go to the criminal code, right? I want to go to. If we don't have one for Victoria, then I'm just going to go to the charter. All right. We've also got a bunch of other ones too, which I can show you, which are kind of different. I just want to have a look at the criminal code. I can show you the Summary Offences Act too, which is the one that's lower than this, which opens the judge up. So I'm going to show you this one first. Let's go down to absolute liability, self-induced intoxication, strict liability, proxy, commission by proxy, conspiracy. Let's just go to conspiracy. Okay, so it tells me that penalty units for the person found to be guilty, the person must have entered into an agreement with one another. The person must be found guilty of conspiracy to commit an offence, even if, and then if they withdrew from the agreement. If when the conspiracy happens, when it ends, it kind of goes into that. I want to look at. So if I wanted to look at the penalties, I'm trying to look for the sentence. Sometimes it'll provide me with the Sentencing Act. So that's what I'm looking for. Crimes Act. Penalty, okay. Define the penalties under 4AA, please. Section 4AA. Okay. So these are the penalty units in law of the Commonwealth or Territory ordinance, unless contrary. Penalty units means, okay. On the 1st of January 2026 and each third 1st of July following that day, the dollar amount mentioned. Okay, so it's telling me how much a penalty unit costs. Reference to means. So it's telling me what I have to penalize a person under these circumstances. Hmm, interesting. Um, so it's not giving me very much room to make my own ruling. Like, imagine if I sentenced them, gave him $20, right? I thought, okay, you're guilty, $20. Right, it's taken away that ability for judges to give them lenient sentences, basically. So I'm looking for. So if I go back, I want to find. Mm, I don't know what's telling me I've got messages for because it shouldn't have any messages. Um, Let's go double jeopardy laws, so you can't be prosecuted twice. Okay, I was going to show you the Summary Offences Act actually as well. Um, let's say, okay, so it's got explosives, terrorism. Let's find out what exporting explosive materials does. What am I going to get for that? Let's say if it gives a sentence here: manufacturing explosives, possession of unmarked plastic explosives. You got defenses to that. What sections add up to a defense? Um, what you need authorizations, conditions and restrictions, criteria. The 7-day limit. Fortified. This will become a federal crime, like a Commonwealth crime, to do this. If you did do this, you'd probably be investigated by the Australian Federal Police, um, which I wouldn't recommend. It contains what elements. So, just say if you had a thing with any of molecular formulas like that in there, that would consider a bomb or bomb making materials. What do you what could be considered to be used as that? I suppose. Um, purpose. Yeah. Says who can use it, who can't. It kind of restricts. So sometimes it's easier just to go. Uh, what is it? It's 10 years imprisonment for carrying explosives. Punishable for 10 years, up to 10 years imprisonment. Doesn't have a minimum term. Yeah, again. Does it even have a minimum? Like, seriously, you should have minimums. Anyway, I'm going to get stuck on that. So if I go to Summary Offences Act, right, if I go to Summary Offences Act, Summary Summary Offences Act, this is what most of people get charged on, hopefully. Lighter stuff, like shoplifting, drag racing cars. That'd be under the Road Safety Act. So, um, sometimes I've seen people. So let's say, um, you're going to see the difference in these ones too. So if we go, let's go common assault. Um, oh wait, you can get imprisonment for 1 year. See, that's your maximum. See how it's maximum, minimum? It's not even maximum. It gives a maximum and a minimum in one, but you must serve a 1 year imprisonment, right? Um, see how it does it again. You must 25 penalty units or imprisonment for 6 months. That's your minimum terms, right? So it's not giving very much leeway to judges, right? So I was going to show this law. So there was a law protecting that just came out. I don't know when it came out. It was probably a little bit ago. Protecting and it was. We don't have stand your ground laws in Australia, so protecting. So we had a whole bunch of emergency services um, get attacked by people, and there was a case where can't remember, can't remember the name for the life of me. Um, I'm just gonna find his name because Mhm. Oh, okay. So I'm just going to show you this one because this is an interesting one because this is one where they brought out a law protecting ambulance workers with minimum terms sentences, but this guy didn't get it, right? So there's this guy named James Harborfield, and basically what had happened was this guy was in the back of an ambulance, and so there's this guy here, I should say, was in the back of an ambulance. I don't know what for. Don't remember what it was. But before this attack happened, I think it was a couple weeks prior to this, the government had brought out laws protecting emergency service workers from attacks. And there's this guy, the ambulance was coming to pick this guy up here, and he attacked them. He started punching into him. And one of the ambulance workers actually ended up getting quite affected by this, who actually has neurological injuries now and suffers from it daily, right? So it wasn't like one of those attacks where nothing happened. It was like quite a serious attack. And he has ADHD, and the judge let him off, right? So there was a minimum. See here how there's a minimum 6 month jail term, minimum, that was imposed on the introduced laws for those who attack emergency services workers. There's a minimum requirement. Minimum means that if you do this, you must serve 6 months. There's no way around it, right? But yet the judge refused to sentence him to a minimum of 6 months. So this is going to be um hard. So if we go and find this case and we want to find out why he didn't get sentenced. We go here. I thought it was stupid at the time. I thought, why don't we could just get away with anything? Yeah. The law, if if it doesn't even uphold minimum standards. So let's find out together. All right. So he recklessly caused an injury to a female on duty paramedic who was a very sizable victim impact statement. The paramedic was not able to return to work as due the date of appeal. Assault on another duty member of the crew, minimum of 6 months, was supposed to be the Section 10AA of the Act says it must be a mandatory minimum 6 months of imprisonment. Right? That's what codified law really is. It tells the judge what you have to do, unless a special reason exists. Special reasons defined in Section 10A that a 22-year-old with no prior or subsequent criminal history, very strong evidence of rehabilitation since attack in the course of a psychotic episode, diagnosis of schizophrenia, experts' evidence from psychiatrists and experts of the sizable risk of significant deterioration in custody, including heightened suicide risk. Special reasons exist under 10A, availability of mandatory term monitoring order pursuant section. So they're saying that, okay, so this guy's suicide risk and his mental health impairment is a good enough reason to not give him the minimum term of imprisonment. Okay. So let's read this a little bit more. Let's see what they said. Okay, so in play, there's complex legislative framework in play. So, one, you've got the legislator who's made a decision, and this is how it should be followed. Minimum term of 6 months imprisonment, and the judge is sitting here going, "Well, actually, this doesn't really work in this scenario, so we need to make a law that does. We need to make a ratio decidendi that does work for this." Because obviously it's not working, right? So best before moving into the appeal, let me say I would hopefully in this case so that before moving further into the appeal, let me say I would hope to perfectly obvious to everyone who has observed this hearing, it is far from being simple sentence. It is something that is an understatement that will come to discuss quite a complex legislative framework in play in relation to the RCI charge as a result of Monica's status as an on-duty paramedic. However, even without those provisions, it would hardly be the case that it is because there is always a level of complexity when sentencing a youthful first offender for a crime of violence which has had a significant impact upon a totally innocent victim. This case is a significant complexities with competing factors scratching me in each and every direction. Stretching me, I should say. Everyone who says sentencing is easy has either never done it or has long since ceased doing it, forgetful of the tensions at play. So the judge is trying to go, okay, well, this is really complex because I've got this first time offender Usually, like, yes, when you get first time offenders in the court, normally you go through a diversion program, right? So your first run in the court is normally, unless it's murder, like you usually go through diversion court, and that usually is avoiding court. And then you get a second, third, fourth time before you go to prison, really. You get a lot of chances. And that's what they're saying. It's pretty much that. In this case, it has accepted that you've been excellent behaviour in the past since the offence, and that there is been a large amount of treatment engaged in since the very nasty events. It is accepted that you have favourable prospects of rehabilitation. It comes down to the need for general deterrence to be adequately reflected in any sentence imposed, and the particular sentencing legislation that comes into play owning the major victim status on the duty emergency worker. I remember this because I remember how vulnerable these workers were, and I remember how scared they were to do their job. They didn't feel protected. That this judge prioritized that man over the emergency service workers. And in fact, just recently, a paramedic was stabbed at Sydney McDonald's, wasn't it? I think it was Sydney McDonald's, where that murderer has been just found not guilty because of their mental health. But that person's a risk to the general public, I'd say. The problem is the judge made a decision. The judge made a decision that the incidents here is we got a first time offender who's been generally well behaved, has no other criminal records, who had a moment of psychosis and attacked. These current legislation does not represent this person. Now, I want people to go home, and when you go home, I want you to think about this. Do you think the judge made the right decision? I want you to think about why he made the wrong decision or why he made the right decision. I want you to think about that. And does it really deter people from doing the same crime? Right? So the whole idea is that should he have been sentenced to 6 months imprisonment? Um, I really want you to think about that. It's going to be a good exercise. But anyway, um, I'm going to let you go so I don't spend too much time yakking on about it. But yeah, Lizzie. All right, bye.